All right, it's 4:30. Call this meeting of Kerrville Planning and Zoning Commission to order. Dorothy, could you please take roll?
Yes, sir. Bob Waller, Garrett Harmon,
Here.
Don Barnett,
Here.
Michael Siegerman, Rustin Zuber,
Here.
David Jones,
Here.
Marty Leonard.
Here.
Thank you.
Thank you, Dorothy. Item 1, Visitor Citizens Forum. Any person with business not scheduled on the agenda is encouraged to briefly speak to the commission. Please fill out the speaker request form and give it to the commission secretary prior to the meeting. The number of speakers will be limited to the first 10 speakers, and each speaker is limited to 3 minutes. No formal action can be taken on these items, as the Open Meetings Act requires formal action items to be posted on an agenda no later than 72 hours before the meeting. If formal action is required, the items will be placed on an agenda for a future meeting. Item number 2, consent agenda. All items listed below on the consent agenda are considered routine or ministerial in nature and will be enacted with one motion. There will be no separate discussion of items unless a commissioner or citizen so requests, in which case the items will be removed from the consent agenda and considered separately. Item 2A is approval of the minutes from the September 21st meeting. Commissioners, have you had a chance to review those?
I'll make a motion to accept the minutes as read. Second.
We have a motion and a second to approve the minutes. All in favor, raise your right hand. Passes 5-0. We move to item number 3, public hearing and consideration. I need to recuse myself from this item, so I'm going to pass the gavel over to Mr. Zuber.
Okay, Sabina?
Thank you. Good evening. So you'll recall the last time that you saw this item, there was some discussion about some changes that you would like to see. This was on for public hearing, not at your last Planning and Zoning Commission meeting, but at the meeting prior to that. We went ahead and re-notified for the public hearing because of some of the changes that we anticipated might be happening, and we wanted to be sure that there was enough public notice to have another chance for a public hearing in case that was necessary. The item that is back before you, I did have a chance to meet and discuss this further with Mike Hayes, our city attorney. He is not here this evening. He's at a conference, a TML conference, but he did send word through me that that basically in favor of simplifying the ordinance that is the verbiage that's before you this evening. In summary, a lot of this the concept really has stayed pretty much the same. However, that first item that you see on the slide, I know that there was quite a bit of discussion on the registration with no fee, but in order for there to be some kind of tracking system, that there was a recommendation, I think on the part of staff, that there would be some type of tracking through registration, and that there be a limit of a certain time period within which that registration was good, although there would be an automatic renewal of that registration from year to year. I did go ahead and leave that in the draft that's before you this evening. One of the things, though, that I have thought through after our public hearing last time and the concerns that were voiced, one of the things that we really are trying to do with this amendment, and I think this has been discussed through several meetings prior to my coming on board here, is to get the regulations out of the definition and really give the code enforcement some tool to be able to respond when we have complaints. Most of the home occupation code enforcement those cases that we've been involved in really have been pretty much the ones that really rise to the top as far as any violations that really are bothersome to the neighborhood. And again, since we only had a definition to go by, that has been a problem for our legal staff, or according to our legal staff. So the requirements for registration are still in there, and that is what was notified. That is one of the things that I looked at, considered removing, but because there was so much discussion with this group, I went ahead and left it in there. You can this evening make a recommendation to strike or change, make some changes to the language before you make a recommendation onto the city council. As long as there aren't significant changes to add any regulation, then we would need to go back and re-notify for another public hearing. Basically, the restriction to have the resident employees, to have employees restricted to the residents only, is still in there. We did strike the 25% of living area. As was pointed out, it wasn't in alignment with tax code, and even though we do see that in some other regulations, I think it was just carried over into the draft that you saw before. It is not in this one. Enclosed storage, that's pretty typical. No exterior alterations, other than alterations that would be in keeping with the residential nature of the property. And anything else related to equipment, nuisances, deliveries, and traffic, I highlighted on this slide because basically I simplified a lot of the language that was in there. And as far as traffic goes, again, that would relate to traffic that would be out of the norm for a residential area, as would then be, and that is up for interpretation, but basically what we would be looking to our engineers, our folks that are involved in traffic, if we had a concern that really rose to the level where we had significant code enforcement involvement. And the registration, again, reconsidering leaving that in there would get us to really looking at and focusing on the cases that we really need to be focusing on versus keeping up with registration and possibly even going having code enforcement cases where we did not intend to. The sign was.
Let me ask a question about registration.
Sure.
How are you going to enforce registration? What if someone doesn't register? I mean, there's going to be a grace period, I'm sure, and to get registered, but assume they don't get registered and we ask them to register, we give them the forms. What if they fail to do so in a timely fashion?
Right. Again, the ordinance would then have some vehicle for going into code enforcement against that person. But if the only reason that we would go into have a code enforcement case open on that is simply because they didn't register, would probably be very low on our priority list. It would give us the means to do that. And that's the way that it's worded in there right now. So the sign language was pretty much left in as had come before you several times. Obviously no illumination of the sign, that it be flush mounted, or that you could have one sign in the yard, maximum of 6 square feet and 3 feet in height. Uses, I actually struck, again, in order to simplify the draft, would be to actually remove the permitted uses, because if you already have performance standards in there, then why have a separate list to possibly confuse matters? So all of these, that whole section I actually struck. But then keeping in the prohibited uses to make it clear that these would be the types of uses that would be specifically prohibited. Oops. And that's all I have on this item. We do recommend approval to the city council as we go forward.
And we need to have a public hearing.
Yes, sir, it was re-advertised
Okay.
for a public hearing.
Okay. All right, we will begin the public hearing at 4:40. Anyone wishing to speak on this issue? Okay, seeing no one, we'll close the hearing at 4:41.
I might be asking a question that we've already answered before, so forgive me for that. But when it comes to again, going back to registration, what exactly, rather than what will happen, like Don asked, if they don't register, what will the city actually use that information for moving forward, besides the code enforcement? Like, what will they use just knowing that person A is doing this in their building? Does that make sense? I just want to make sure that we're just not doing it just for the sake of doing it, but what will it actually tangibly give you guys the ability to do?
Well, I'll also let Danny Batts, who works with code enforcement cases quite a bit, answer this. But from what I understand in the past, the discussion had been to have something on file so that if we did get a complaint, that we could talk to the complainant and explain what we know is going on and how they're meeting our the requirements that are in the home occupation regulations. Is there?
Yes,
am I
that's
understanding?
correct. Basically, if we get a call, which we will, get a call from someone who's complaining about maybe it's a daycare in someone's home and they've got quite a few kids running around the yard and they want to know what's going on over there. Well, we don't have any way of responding to that without sending an officer out and commit city resources to investigate what's going on. What type of home occupancy is it? Some of the council members had voiced, if they were looking to buy property and they noticed a lot of traffic on the street, maybe it's a daycare, maybe it's some sort of business, they could at least call the city and say, hey, what's going on at this residence? Before I invest in a piece of property, I'd like to know what's around me, and so that was one of the ways to do that, was to have them registered. Right now, we have to respond to a complaint that comes in. So we have to take city resources and send an officer out there and investigate.
This is just saving time.
Yeah,
This
it would save some time.
going
Save
out.
some time, and that's what they're mainly looking for, was just to have it registered. It'd be right there. It's no cost to register, but it would save a lot of time when someone calls in and wants to know, what's going on at this address or that address or whatever. So we could just easily look at it in our computer and say, oh, well, it's a licensed whatever, whatever the business is.
Wouldn't you agree, though, at managing that ever-changing pool of information is going to create some time?
It'd just be a list in a computer system. It's not hard to access. Just pop it right up, And if someone, like I said, if someone moved out or whatever and they didn't notify us, then, we wouldn't have any way of knowing unless somehow someone, told us that they were leaving, because that was just what they were looking at, was basically to have a database of businesses in the city.
What do we do if this moves forward? Because it's still got to be approved by city council, correct? So moves through all those channels. How will the city inform current people that are running business out of the home to do this? Is there going to be a plan to say, okay, now you need to register, or the ones that are not registered? Is there going to be some kind of marketing or?
We ought to do a public information. I think we should do a public information release letting people know that we do have a newer or revised ordinance that does require home occupancies to register.
Especially since it'll be code enforcement. I don't want us to do this and someone that's been doing a fine job to all of a sudden get hit. Well, I know it's not gonna be a high priority, but all of a sudden they could be out of code. So
if we go out to a complaint, and they're not registered, we simply would have the forms with us and ask them, maybe a simple registration form, ask them to either fill it out then or bring it in at their leisure so that we could put it into the system. It's not something that we're looking at as a crackdown, go to court enforcement tool. It's just a way to have a database to be able to respond to questions from people who call into the city.
Yeah, it just seems like to me that under all those scenarios, you're responding to a complaint. So whether they're registered or not, it's
it's easier to respond to it over the phone than it would be to have to send an officer out there to look, to see what's going on. If they're not there, if someone's not home, you're gonna have to make multiple trips to find out, you know, so it's either or, you know, just both accomplish the goal. I think the registration makes it a little easier for the office staff to, you know, you don't even have to engage a code enforcement officer at that point. Just the administrative staff there can just answer the phone and answer the question, you know. Plus, this is also gonna be online, so they can read this themselves and
Sure.
see if they think it's in violation.
Sure,
Then they can say, well, this is what's happening, and give you more information.
right.
My concern is about construction companies or construction people, because they're usually coming and going. Do you feel like this covers that fairly well?
Is, you know, whatever they're allowed in the ordinance to do. I mean, construction companies can obviously, you know, be a home occupation and they can be there. And so, you know, we don't get too many calls on that. I don't think on construction companies, but we do get a lot of calls just on, you know, businesses that are out there. And I would say that the ones where we get a call are where we have a lot of storage of outdoor materials, you know, and it's apparent that somebody is operating a business in a residential neighborhood. The ordinance is supposed to restrict that, but we have no way of knowing what it is or who it is unless we go out and investigate it and then commit time to do so. But, you know. Danny, if you didn't have the registration, I mean, would it function? I mean, I
Yes.
guess where I'm going with this, I
Yes,
see
it
that
would.
one as the area where I think a lot of people, that's gonna be the area of pushback, and it doesn't seem like it's the most important part of it, but.
Yep. You know, it's kind of ties into a couple things here in the city. One that we don't do here is either we don't do a business license here in the city. Yet we have folks who move into town and open up a business in an area that may not be zoned for that type of business. And we don't find out about it until, let's say that person comes in after he's invested a ton of money and wants to get a sign for his business. You know, I mean, he's invested all that money. We find out that, oh, you're not zoned for that. You're not allowed to be there. Everything you've invested now needs to be gone. Had we had a business license, even if we didn't charge for the business license, we could go through that zoning issue before that ever happened, and we don't do it. So registering is kind of a way to help regulate, to make sure they can do what they want to do in that specific area and zone. If you don't want them to register, then it just becomes a code enforcement issue, and then if they're in violation of it, and then it becomes a legal issue. So hopefully with registration, somewhat you might could head off some of those issues, maybe, you know, so. I think that's where the registration in comes in.
Okay, thank you.
Okay?
Any other thoughts, commissioners? I like the document, my only hangup is the registration. I'm not seeing that it's, I see a lot of downside and not much upside, but.
Well, I see the upside he just pointed to. You know, the upside is if somebody's going to start a business, they can find out if they can do that business there. Because there's a lot of areas here that are kind of, I don't know if they're conditional use, but they kind of run into residential areas. Like Water Street, you start getting businesses lined up on Water Street. I don't know if it's zoned properly or not for that. And they may not either. I mean, you know.
And I guess that could be a bigger discussion about business licenses rather than just the home occupations.
Yeah.
I gotta say, I was kind of, I know that eventually, and it still goes to city council, and there'll be a discussion there, I'm sure as well, but registration just seemed, but I think I was just kind of convinced with the last statement as well, it could be that buffer that could save a business from investing a lot of money if they simply just registered. I kind of got turned on that one. I agree that I've had some hangups on there too, but I think that I will say that I was just convinced with that last statement. If we can save a potential business from making a big investment, even just 5 years from now, then I think that it'd be worth it.
Well, with the home but that example was not a home occupation. That was a storefront business. Yeah. So I don't think the investment of money is really an issue with the home occupation.
Well, I mean, I think that if, I started if I bought a bunch of stuff and I was starting something in my home business, the same thing, invested money, and I couldn't do it. Firearms, for example, I think that that's still a valid point, that it could be that buffer to save potential heartache for somebody. But I also will point that we're going to send this to City Council, and it's going to be a whole other discussion there at the next meeting. If we approve this today, it will be the next meeting that City Council sees it.
Well, then we would have to notify the public hearing at the city council level, and I don't believe we have enough time to advertise for the next council meeting. So we're likely looking at November.
Sabina, there's one typo. It's on advertising and signs where it says, I believe it just should say one non-illuminated freestanding sign.
Okay.
Garrett actually caught it. I can't take credit for it.
Thank you.
Even while we're cruised.
Well, I'll make a motion that we accept it
I'll second the motion.
without the registration requirement.
Pull back my second.
Do we have a second? We do not have a second, so that motion fails.
When you started talking about it, you said you were going to set things aside here, and that you were going to have the registration set up separately, and then for code enforcement have the scope or the standards in a separate. I'm just trying to get your logistics straight on this. I mean, are we looking at this exact document that's what you're asking us to?
Right. The next step here, because when we bring ordinance amendment language to the Planning and Zoning Commission, what we're bringing to you is the meat. So what we'll do after this, if you recommend for approval, is that we will turn this over to legal to put it into their format. And then that's the document that goes on. In other words, they'll have the whereas statements, and it'll have the Planning and Zoning Commission action on there, and it'll be assigned an ordinance number. But this is the actual meat that then would get translated into the ordinance language.
Okay.
Any other motions?
I'll make a motion that we approve we can't, it's not an ordinance, we approve give me the word.
Amendment.
Amendment as presented to us.
I'll second that motion.
We have a motion and a second. All in favor, raise your right hand. Those opposed, same sign. Passes 3-1. All right. Wait for Garrett, I guess.
Yes.
You after? All right. Pass the gavel back to you.
All right, thank you, Mr. Zuber, for handling that for me.
Sure.
Next item, item 4, discussion. We have a discussion item on ordinance amendment regarding wireless telecommunications facilities. Sabina?
Yes, thank you. So last time this item came before you, we discussed the impetus for us reviewing our wireless telecommunications facilities ordinance, which was passed in '03, and we started discussions on where we felt that we needed to go with this. Just this year, we had a legislative session at the Texas state session that basically requires that any city allow these network nodes, the network poles, and the transmission facilities to be located in city right-of-way. It's a little bit of a different animal than you normally see, because what you're looking at is regulation on private property. So zoning and subdivision regulations regulate private property. Not a whole lot in the public right-of-way other than when you see rights-of-way shown to you on a plat. But the zoning normally, and our zoning regulations normally apply to private property, so anything that is on this side of a right-of-way line. So we looked again at the current ordinance and recognizing that it does comply with the Federal Communications Act, that there have been several regulations that by the federal government that we're not allowed to do, and those continue today. And that is basically that we cannot entirely prohibit the provision of wireless service. We cannot deny service or a tower or any type of wireless telecommunications facility based on our local determination that the emissions are not safe. So that has been predetermined by the federal law. We do have to have a timely review process, and that carries forward through this new legislation as well, through the state legislation. And if we do deny a pole or a tower, then we have to have sound reasons, and those reasons have to be in writing. So those are going to carry through, and those carry through into the 03 ordinance. So what we're looking at is reviewing that ordinance and making some recommendations for amending that ordinance or adding to it. Essentially, what we're not looking at amending anything that would apply to the towers. What we're looking at is much smaller in scale. What we're talking about are these, and it is new terminology, the network nodes and the network poles. So essentially, this is a depiction of some of the of what we'd be looking at. Because the access to our city rights-of-way applies not only to the city right-of-way itself, to the area that is between the street pavement edge or curb, and usually anywhere from 10 to 20 feet behind that. But we'd also be required to allow them access to city poles. So those would be your traffic poles and telephone poles. Any kind of pole that is owned by the city or a utility that we would have to allow access to. So we're looking at smaller facilities in what we'd be looking at regulating. So the Senate Bill 1004 basically, like I said, requires that these network nodes, the support poles, and the network transfer facilities are permitted within our right-of-way. Just another sample of what that would look like. Let me go back here. It did leave open some areas that we can still regulate, and that's what we're looking at, focusing on before the commission this evening in this discussion. So basically, let me go back here again. So we're looking at attached nodes, which can look like just basically adding width to an existing pole, or in some cases looking more like you see on this slide. And some that are really relatively small in nature, and that fit in with, frankly, the pole that it's attached to. In some instance, they would simply add height, like you see in this slide. So you have an existing light pole, it adds some height. In others where it adds width, either on the top of the lamppost or somewhere in the middle. And they can look fairly attractive, utilitarian but attractive. In some cases, maybe out of scale, though, for the area that they've been placed in. This is one example where if this were on a major highway, it may not appear as intrusive. But we're starting to potentially get into some areas that we might be interested in regulating. Here's one that's relatively small, but the way that it's attached is not as attractive.
I was like, that's permanent.
That's the way I changed my tire. And also the wires, exposed wires. And I did have some same with Mike at our last meeting. Mike Hayes, our city attorney, talked about 2 other communities in our area, Fredericksburg and Bernie, that did adopt, and I put an excerpt of those regulations in your packet, that have put in place some design standards for these facilities. This is an example in Fredericksburg, and you can see it is attached to the pole. It is just a single pole that is parallel to the existing pole, and then just traveling up with your eye to show you, basically it's just the one singular pole next to the existing pole. And then another example where there were actually, this is also in Fredericksburg, it does meet their design standards, their design guidelines. Saw quite a bit of these where you have the three poles that look like they're encased in PVC piping. Just to give you an example. So from that, I've found several in my research, several guidelines, design standards already that are being kicked around in other communities, and basically, my understanding is that what we can do with these telecommunication facilities is that we can designate certain areas as design districts. And within those design districts, then we can include what they call reasonable design standards. And so my recommendation is that we look at what is in your packet, similar to what the city of Fredericksburg did. It limits the cubic square feet of the area that that the nodes can encompass. It does have some added restrictions in there for the equipment boxes and the meters. But that we also consider, and this is what I'm bringing to you as a discussion item as well, is to potentially also include concealment requirements. I'll show you in a second what that might be. That we do go ahead and limit the location within narrow residential rights of way. My understanding is that would be a right of way that is 50 feet, that is less than 50 feet in width. And we do have several of those in our older areas. I can tell you that our current design standards, our engineering design standards for rights of way, for residential right of way, is 50 feet in width. So the newer areas would not be, would still be open to having these types of facilities exercise their right to locate in them. But that we could at least go into the rights of way that are less than that. So we're looking at our older areas of town where we have very narrow streets.
How is this addressed with underground services, if everything's underground?
Well, and that would be another thing that we can do, is to require the fiber optic lines, the wires for those to be underground for the actual service, which they tend to be.
They tend to be, but if the only thing you have above ground is probably a street light, that's the only access point that you would have, or they would have to attach to. And I mean, the concealment ideas, I think it has to comply with that for me.
Right, and this is something that I saw as an example, actually, that is not in your packet. That's an example from a code in Shenandoah, Texas. and I've reworded a little bit, but basically that these are examples, that they be hidden behind a facade, hidden behind materials that match the surrounding materials. So if there's a piece of metal and you've got a metal pole, for example, but it matches the pole, that would be an example. Blended with the surrounding area design or painted. And disguised with artificial, the example I found said branches, but I don't want to, really any kind of artificial plants, artificial flora, rock around here, or anything similar really that's found within our hill country area. I don't know if we'd be looking at palm trees here.
Be a fake deer.
A fake deer. Yeah, anything if they want to get inventive. So that's just, there's no public hearing for this yet. I just wanted to have some focused discussion on bringing this forward under the state regulations that we can still regulate.
I had a question regarding, you talked about utility companies. If the city says, yes, you can have it in the right of way, could KPUB or Windstream say that's fine, but not on our pole?
That's
And-
really a good question.
And then does that trigger them putting a new pole, the telecommunications company putting a new pole right next to that or something? Are we getting more poles at that point?
Well, I do know that KPUB and other utility companies are having these discussions as well, because their concern is for the operations and their own operations and making sure that there's no interference there.
Mm-hmm.
But this applies, as my understanding, applies to them as well.
Mm-hmm.
So there are design standards that are much more broad, where they need to be concerned about their operations, and so theirs are probably going to be a little slower in coming forward, but we are having broader discussions with them as well.
How did Fredericksburg address this issue with their co-op or utility facility? I mean, those are on utility poles.
Right. Yes. The excerpts that I pulled out really were to focus more on the aesthetics of them, but Fredericksburg also that's out of a larger ordinance that addresses the operations and the attachment, the means of attachment as
Must be
well.
some agreement, I guess, is what you're referring to. There has to be an agreement they're going to allow this to happen, or maybe they're required to let it happen.
My understanding is that they're required to let it happen, and therefore, but within reasonable standards, right?
Or
to
unless they
protect.
deny it, they have to have supporting evidence of why. It's, interference with their operations, and can have the data to back that up.
With these, there is a requirement for those large towers to come before you under a conditional use permit, and my recommendation is that we basically keep the large towers, the major structures, still coming through that process and giving you the opportunity for that. With these, because we are required to allow them within our rights of way, these smaller nodes, my recommendation is that we set the standards, and then that we allow that review to happen at the staff level versus having to come back before you each time.
In those regulations, are we allowed to limit the number of nodes attached to a single pole? I mean, you could have 3 different communication companies wanting to use the same pole, and at some point it gets overloaded, and then it starts, no matter how much concealment you do, you got a bunch of stuff stuck to it. And so, I guess is that allowed in our regulations? Or even for KPUB or any of the other utilities, is there a limit that we can put on how much is attached to an existing pole?
That is a good question. That would be a question that I'd want to float by our city attorney. That's because it's not real clear.
Right.
It's not
And
clear
what-
in the state regulation on this, is it?
Pardon me?
It's not clear in the state's document of what the state.
Right, it talks about reasonable, and remember too that we're only talking about those areas that are designated as design districts. So the next, oops, let me go back. So this is the summary of the
Okay.
recommendations, is that you designate the Guadalupe River Trail, because the trail can actually go onto private property as well. And the CBD, so our more historic downtown area, the Gateway, which is Sidney Baker into town, and the river, the Guadalupe River districts, that we designate those as design districts, and therefore these regulations would apply in those areas, and they would not apply elsewhere, because we're limited to the historic designated districts and the design districts.
Do you have a technical definition of the scope of these, I always think of these as being line of sight,
Okay.
pole to pole, and so the higher you are, the more coverage you have, or do you have any sort of technical definition of we now have the right to do this, and we have to have one of these things every 100 yards, 50 yards, 2 miles, whatever. Is there any definition of that? Do we know a magnitude of what we're talking about?
It's a good question. I'll see what I can find. I've been looking for that myself. I'll tell you that.
Oh, okay. Well,
It's yeah, and because of the technology is constantly changing, that answer might change in the next month.
I was about to say, it's, your immediate thing is height, therefore you go to the water towers, you go to the existing radio towers and things like that, and you get, then you have some sort of drop-off of signal strength, and therefore you have a coverage area that's very well defined. And it would seem that that would need to be taken into consideration before we talk about concealment, or, how many of these things are required. In other words, they've already done their homework. The state has told cities that they've got to put them in their right of way, but then how many and how far apart, and how many companies are represented, like Don was saying, multiple users. So that needs some definition, I believe.
And also, if a company decides that they're going to move from a different location or abandon it or go out of business, are they required to remove their apparatus afterwards?
Good. Well, yeah.
I have seen that in the ordinances that I've looked at. From more of an operations standpoint, is that when abandonment, it is in other ordinances, I can tell you that,
Okay.
to require those things to be
Absolutely.
removed, then
To be
if they're abandoned.
left in the original state.
Mhm.
Did Fredericksburg designate, design districts
Yes,
in theirs?
Oh, yeah.
yes.
Because their whole town is designed. They think.
Historical
Designed
district.
to extract. Yeah.
Well, I have a question regarding the design, the designated districts. What is the difference between that and then the limited location within city parks and residential ORWs? Like, what is the difference between limitation here but designated here?
Well,
sense?
there are actually two separate areas where the state lets cities still regulate. And one is this reasonable design regulation, and the other is limited, where we can limit them. So they're actually two separate classifications. One is where we can limit, and where we can limit them is in the residential areas and in city parks.
So then in those cases, we'll just say, we're only gonna allow this much and that's it, or the city will, or this commission will.
It is left somewhat open for what is meant by limit, but I'll do a little more digging and see if I can further define what is meant by limited, and can we
Yeah, I guess
completely limit them?
Yeah, because I guess my question is the difference. It's almost as like, well, just designate. It seems to me there's, I guess it's more of a legal term in that sense, what the differences are. But I mean,
Yeah.
limit could also be one if the city decided to, right? Or one spot. So I guess I get just what does limit mean?
Okay. if we can't get further definition of that from what the state, what was in that Senate bill, then we might have the discussion of how much are we willing to test that, and kind of put ourselves out there and at what cost potentially.
Well, is it something that if the city attorney has questions, can we call the state? Is that like something we can do? Do we call AG or something where we can talk about the language and what's the goal of it, or is it just going to be left up to the city?
Well, I'm sure he's got his resources and can that Mike does.
Yeah,
Mr. Hayes, but it's been my experience in working with other city attorneys is that when we're dealing with something that's this new, where if it isn't clearly defined in the legislation, then it is left up to interpretation, and then it's left up to being further defined in other legislative sessions or even through case law and tested that way. So it becomes a question of how much we're willing to push it and how concerned are we as a city.
Well, I guess I agree that we, designating the design district is important. Taking advantage of whatever limits or regulations that we can legally to be able to do that. And most of the examples that you showed I felt reasonable aesthetically or visually. I do feel that putting some type of limit on exposed wiring would be pretty important in my view. There will, in many cases, there will probably have to be some, but if we can limit it to 24 inches or less, that would be great. But I guess understanding what we're, the amount of regulations and limits we're allowed to work within, understanding what our parameters are will be key before we start getting into too much more detail. Because I'd hate for us to have several weeks of discussion and meetings and come up with something and then they say, oh no, you can't do that. So understanding what parameters we're allowed to work within, I think is a good first step.
Okay, so before I schedule it for public hearing, I'll make sure that we have legals okay on the points, on the bullet points.
Mm-hmm. All right. Any other discussion or questions from the commissioners on this item? Okay. Next item is staff reports.
I have nothing to add to that. Thank you.
Okay. We have items for an agenda on our next scheduled meeting.
Yes, we do.
Okay. All right. Okay. Next item is adjournment. Looking for a motion.
So moved.
Got a motion? Do we have a second? All in favor of adjournment? Carries 5-0. We're adjourned at 5:20.